Is appealing a judge's ruling that restored collective bargaining powers to public workers. As we first alerted you on Monday, a Dane County judge ruled in favor of reversing the law known as Act 10. In a First Alert update, Drew Best joins us now live in the newsroom with reactions to the appeal. Drew.
Bill, Monday's ruling represented a major legal victory for public workers and teachers unions alike. Everyone involved on both sides anticipated the appeal, saying they are prepared to take on the next steps.
We really want to ensure a strong workforce in our schools across the state, and this is one step forward to doing that.
Former Governor Scott Walker, who signed the bill into state law back in 2011, continues to be vocal in support of Act 10.
Remember, this is a law that has been upheld multiple times in both state and federal court. Nothing has changed in regards to the law except the politics.
In the docketing statement provided to Dane County Court, the legislature's attorney says they intend to make three arguments in their appeal of the ruling. First, they say it's rational to treat some public safety employees differently than others. Secondly, any decision that's favorable to the unions should be limited in scope, not statewide. And finally, the lawyer argues an appeal decision not in their favor should only invalidate Act 10's definition of public safety employees, which may cause police and fire unions to also lose their collective bargaining powers. Wirtz Olson says everyone who celebrated yesterday's decision knows there's still a long road ahead.
We will not rest until free, fair, and full collective bargaining is restored for public workers in Wisconsin.
The former governor also setting the stage for April's state Supreme Court election, which could revert the high court back to conservative power.
If you have an activist court, a conservative court in a couple of years, if you abided by the same measure, could undo any of the work that a future Democrat or Democrat legislature could do. I don't think anybody wants that in the state.
State legislature is seeking oral arguments in front of the judge on a court date that has still yet to be set. Bill?